Big news coming out of California today. The state's ammunition ban is heading back to court, and this time, the Trump administration is jumping in to help strike it down. Let me break down what's happening in simple terms. There's a case called Road versus Bonta that challenges California's strict ammunition laws. Last year, a three-judge panel at the Ninth Circuit Court of Appeals ruled that California's ammo restrictions violate the Second Amendment. That was a huge win for gun owners. But here's the problem. Every time gun rights supporters win a case in the Ninth Circuit, the court's full panel, called the en banc panel, often steps in to review it. And unfortunately, this larger panel has a history of overturning pro-Second Amendment rulings. That's exactly what's happening now. The en banc panel has agreed to review the case, and oral arguments are scheduled for March 23rd. Both sides are preparing their best arguments, hoping to convince the judges to rule in their favor. Here's where things get interesting. The Trump administration, through the Department of Justice, has filed what's called an amicus brief in support of striking down California's ammunition restrictions. This is fantastic news for gun owners. When the federal government weighs in like this, it carries significant weight. The DOJ's arguments could influence the judges and might even help this case reach the Supreme Court eventually, where these unconstitutional laws could be struck down nationwide. We've already seen the Trump DOJ participate in other Second Amendment cases. They argued in the Pica case in Illinois and are currently seeking to argue before the Supreme Court in the Wolford concealed carry case. It's possible they might even request permission to present arguments during the oral arguments in this case on March 23rd. Let me explain what this case is really about, because California's ammunition laws are pretty extreme. These restrictions were passed through something called Proposition 63. Under this law, every time you want to buy ammunition in California, you must pass a background check. There are two types of checks, a basic eligibility check and a standard eligibility check. Both require fees, and one can cause delays. But it gets worse. California residents cannot buy ammunition online and have it shipped directly to their homes like people in most other states. Instead, they must go to a licensed gun dealer, called an FFL, and run a background check every single time they want to purchase ammo. Think about that for a moment. If you want to go to the shooting range for practice, you need to pay fees and undergo a background check just to buy bullets. If you want to buy ammo for hunting season, same thing. It's an expensive, time-consuming hassle that makes exercising your constitutional rights extremely difficult. This case has been on a roller coaster ride through the courts. It started with Judge Roger Benitez in District Court. He reviewed California's ammunition law and ruled that there was no historical tradition supporting such restrictions. He found the law unconstitutional. California immediately appealed to the Ninth Circuit. Oral arguments were held back in November 2020 before a three-judge panel. But then the ruling was put on hold. Then something important happened. The Supreme Court issued its landmark ruling in a case called Bruin in 2022. That decision changed how courts must analyze Second Amendment cases. The Bruin ruling requires courts to look at historical tradition, whether similar laws existed when the Second Amendment was written. After Bruin, the Road case was sent back down to Judge Benitez to review it again using this new framework. Judge Benitez reviewed all the evidence and reached the same conclusion. California's ammo ban is unconstitutional. And you might remember what happened next. There was this brief Freedom Weekend in California where people could actually order ammunition online and have it delivered to their homes. Gun owners could buy ammo at stores without running background checks. It was like experiencing what Americans in other states take for granted. But it only lasted a weekend. The Ninth Circuit quickly issued a stay, putting everything back on hold. Eventually, a three-judge panel at the Ninth Circuit reviewed the case and sided with gun owners. They struck down California's ammo ban as unconstitutional. But California wasn't done. Governor Gavin Newsom's administration requested en banc review, and the Ninth Circuit agreed. That's where we are now, waiting for the full panel to hear arguments on March 23rd. The amicus brief filed by the Trump Department of Justice makes several powerful arguments. First, they argue that California's point-of-sale background check system violates the Second Amendment because the right to keep and bear arms necessarily includes the right to acquire ammunition. This is common sense. Without ammunition, firearms don't work. The constitutional right becomes meaningless if you can't actually get bullets. Second, The DOJ explains that under the Supreme Court's Bruin framework, any law that regulates conduct essential to exercising the Second Amendment must face constitutional scrutiny. It doesn't matter how small the burden seems. If it interferes with your constitutional rights, courts must examine it carefully. Third, they point out that California's system imposes recurring fees, short authorization windows, unpredictable delays, and widespread erroneous denials. All of these factors substantially interfere with law-abiding citizens trying to exercise their rights. People get wrongly denied. People face unexpected delays. People have to pay fees over and over again. Fourth, and this is crucial, the DOJ argues there is no historical tradition of requiring background checks every time someone purchases ammunition. Throughout American history, people could freely buy ammunition. The Founding Fathers never intended for citizens to need government permission slips to buy bullets. Because no historical analog exists, California's law fails the test required under Bruin. The DOJ also makes another important point. California's ammunition system doesn't actually serve any legitimate purpose. Instead, it's designed to frustrate people from exercising their constitutional rights. Historical sources, commentary from the founding era, and Supreme Court precedent all draw a clear line between legitimate regulation and unlawful infringements. This law crosses that line. It operates as a pretextual barrier rather than a genuine public safety measure. What does this mean in practical terms? The real effect of California's law is simply to discourage law-abiding gun owners from accessing ammunition for lawful purposes like self-defense, target shooting, or hunting. It doesn't stop crime. It doesn't keep guns away from prohibited persons. All the data shows that none of the claimed public safety benefits actually happen. Think about it logically. Criminals don't go through background checks to buy ammunition. They get it illegally, just like they get illegal guns. The only people hurt by this law are law-abiding citizens who follow the rules. Because this ammunition background check system is actually tailored to restrict rights rather than to regulate anything meaningful, the DOJ argues that the Ninth Circuit en-banc panel should rule in favor of the plaintiffs. They should side with Kim Road, the lead plaintiff, and the organizations challenging this law. They should agree with Judge Benitez that this law must be struck down. The DOJ's arguments will definitely come up during oral arguments on March 23rd, even if DOJ attorneys aren't physically present to argue. The judges will have read the brief, and the lawyers on both sides will reference it. But there's another interesting twist that could affect this case. Right now, two other California gun cases are seeking Supreme Court review, one challenging the state's rifle ban and another challenging the magazine ban. Both of these cases are going to conference at the Supreme Court this Friday. If the Supreme Court agrees to hear either of those cases, the en-banc panel will almost certainly put this ammunition case on hold. They'll wait to see what the Supreme Court says before making their decision. Would that be a bad thing? Actually, not necessarily. It would mean the Supreme Court is finally taking up a major Second Amendment case that gun owners have been waiting for. And while this ammo case is on hold, the en-banc panel can't issue a bad ruling. Right now, the Ninth Circuit seems to have little fear of Supreme Court consequences, so they might rule against gun rights. But if the Supreme Court takes up the rifle ban or magazine ban, the Ninth Circuit would have to wait and follow whatever the Supreme Court says. Then, this ammunition case would be analyzed in light of the Supreme Court's new ruling. That could actually lead to a better outcome for gun owners. This case is about more than just California. If California's ammunition restrictions are allowed to stand, other anti-gun states will copy them. They'll make it harder and harder to exercise Second Amendment rights by restricting ammunition rather than guns themselves. But if this law is struck down, especially with help from the Trump administration, it sends a message that the government cannot end-run around the Constitution by making it nearly impossible to get ammunition. The Second Amendment guarantees the right to keep and bear arms. That right is meaningless if the government can prevent you from getting the ammunition that makes those arms work. This case will likely take months to resolve, and it might even end up at the Supreme Court. I'll keep you updated as things develop. But for now, it's encouraging to see the Trump administration standing up for gun owners and arguing that these unconstitutional restrictions must go. The fight for our constitutional rights continues, and with the federal government finally on our side, we have a real chance of winning.